The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your usually bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of IJ's Center for Judicial Engagement, as well as IJ litigator Josh House. This week on the show, federal marijuana prosecutions, sex offender registries, bogus arson charges, and judicial speech. Evan, kick us off.
So this case comes out of the Ninth Circuit. It's called United States v. McIntosh, and it arises from a series of federal prosecutions for medical marijuana use. The people who are being prosecuted seek injunctive relief on the grounds that even though federal law generally prohibits the use of marijuana even for medicinal purposes, the most recent congressional general appropriations bill, had a rider that specifically prohibits the use of federal funds for federal prosecutions of individuals who are using or accused of having used medical marijuana in states that allow medical marijuana use if those individuals are acting in substantial compliance with their marijuana laws. Specifically, they are challenging their prosecutions on the grounds that the Constitution, in its appropriations clause, actually forbids them from being prosecuted. The appropriations clause says that no money shall be drawn from the Treasury except as appropriated by law, and yet these individuals are being prosecuted on the basis of funds that an appropriations bill has specifically prohibited them from being prosecuted from drawing upon.
Tell us about the defendants in these cases, Josh.
The defendants are two marijuana growers and one marijuana store from both California and Washington. And this case has to do with people like the defendants who are actually in compliance with state law and yet being prosecuted under federal law. So the issue in this case is not whether people can openly flout state marijuana laws and then also get away from prosecution. It's actually just narrowed to whether or not you can be prosecuted under federal law if you're in compliance with state law.
Yeah, and it's also not a question of whether the fact that you are in compliance with state law insulates you from a federal prosecution on a general scale. This is an appropriations rider that specifically prohibits the federal government from doing something that it would otherwise be able to do in the course of prosecuting individuals for violations of federal crimes.
And it's important to note there that this is actually not a case about kind of states' rights. This is simply a case about whether or not the DOJ can use funding appropriated by Congress in a particular manner against particular individuals.
And this is a point that Judge O'Scanlan really stresses throughout the opinion. It's a very careful, considered, well-reasoned opinion. And there's also a nice point that I appreciated about the way that separation of powers can actually protect individual liberty. We often think of separation of powers, distribution of powers between legislative, judicial, and executive branches as kind of this abstract thing. But, the appropriations clause is ultimately designed to protect liberty in the following sense. If the executive branch of the government can, on the basis of its own resources, decide how to spend it without any monitoring by the people's representatives, individual rights are very much at play, are very much vulnerable. And I think that it's an important thing to understand in evaluating these separation of powers challenges.
So, Josh, the defendants here haven't actually been convicted, and yet they are managing to get in the courthouse doors. Tell us about that.
Yeah, so the procedure here is a little unusual. It's an interlocutory appeal, which means that it's been appealed after an earlier court ruling. This is just simply following the indictment. And after the indictment, they asked the court to enjoin any further proceedings because those further proceedings would require funding. And interlocutory appeals, that is, an appeal before a final judgment, are only allowed in very particular cases. So what we have here is because it involved asking the court to enjoin the further prosecution, that is specifically allowed under U.S. statute, under federal statute, and therefore the court found that the court had jurisdiction over these interlocutory appeals. Standing's also interesting because it involves a separation of powers claim. The court had to consider whether or not it was justiciable to essentially enjoin the further prosecution based on a separation of powers claim. Does the separation of powers clause or doctrine, actually kind of confer individual standing? Does it protect individual liberty? And the court said, yes, it does.
So where does this case go next, Evan?
This case goes back to the district courts, which will then determine whether these individuals were in substantial compliance with state law. So this isn't the defendants win, they're off the hook, it's a successful constitutional challenge. We now determine whether they can claim the coverage of the appropriations rider that specifically said, if an individual is in substantial compliance with state law, the federal government can't prosecute him, and therefore it would violate the appropriations clause to prosecute him.
Okay, let's move on to the next case, which comes out of the Third Circuit. Josh?
So this case involves a woman named Michelle Black who owned a Pennsylvania home, and she intended on selling it. Before closing the sale, there were electricians in the house doing some much-needed repairs, and a fire broke out. Now, when the police showed up and investigators showed up, they apparently were told or believed or somehow came to the conclusion that because the electricians had turned off certain outlets, that an outlet in the room where the fire broke out was not powered, and therefore it could not have been an electrical fire, and that it must have been some sort of other cause. There were matches found, and eventually the police come to the conclusion that Michelle Black herself had set fire to the home. Black is eventually arrested but released on bail, and is forced to attend numerous court proceedings to defend herself. Now, she's actually based in California, so she's flying across the country to attend all these court proceedings. And at these court proceedings, she, through her attorney, present evidence that the officers fabricated the evidence about the matches, or about the arson, I should say, and suppressed exculpatory evidence regarding the outlet that would have, I guess, shown that she was not guilty of arson. And eventually, the jury agreed she was found not guilty. And she filed a suit shortly after, alleging various claims under the 14th and 4th Amendments, in order to kind of vindicate her liberty rights that she felt were violated by the wrongful prosecution.
So what's the question in this case, Evan?
So there are, as Josh pointed out, there are two central constitutional claims. First, that she was seized for Fourth Amendment purposes by the police. First, when she was interviewed and told that she could not leave. Second, when she was forced to make her way across the country some 12 to 14 times on pain of having a warrant for her arrest issued if she did not comply and did not show up in court. So that's the Fourth Amendment claim. The 14th Amendment claim arises from the use of fabricated evidence in the course of her prosecution. Due process of law guarantees not only, notice, presentment, indictments, but also access to a proceeding that is not tainted in particular ways by either irrationality or by corruption. And the courts in both cases determined that she had a colorable constitutional claim. She's been seized for Fourth Amendment purposes, and the introduction of fabricated evidence into a prosecution is a due process of law issue.
So it's actually a closer question than it might seem, because previous courts have held that, listen, she wasn't convicted, so her rights weren't violated.
Right. So she's, brought to trial. She's forced to mount a defense that will prevent her from being incarcerated. And yet that is not a deprivation of liberty, according to the Seventh Circuit. The court in this case expressly disagrees with the Seventh Circuit, says that, look, insofar as you're forced to mount a defense against yourself, insofar as the process itself has been tainted by fabricated evidence, that goes to the heart of the guarantee of due process of law, and she has a colorable claim arising from it, even if she isn't convicted.
Josh, what about the malicious prosecution claim?
Right. So under the Fourth Amendment, to bring a malicious prosecution claim, the court has said that the defendant has to show, among other things, that the defendant was seized. This is because the Fourth Amendment prohibits unreasonable searches and seizures. And in this case, even though the defendant was facing prosecution. She was out on bail. There was actually no physical seizure of the person. The court looked past that and said, but in reality, she was forced to attend all of these court hearings in order to defend herself, and therefore there was in effect some liberty restriction, and that liberty restriction meant that she was seized for purposes of the Fourth Amendment.
Yeah, and that's the kind of analysis that really marks this off as an engaged opinion. It would have been easy for the judge in this case or the court in this case to say, look, this individual hadn't been arrested, she hadn't been dragged off in chains, and in the context of the 14th Amendment claim, that she hadn't actually been convicted, therefore she hadn't been deprived of her liberty. But the court looks beyond those formal categories in a very context-sensitive, fact-sensitive way, looks at the reality that, yes, this individual was threatened with the reality of arrest. She didn't have a choice about whether to go to these hearings or not. And the fact of the matter is that she could have been convicted even though she wasn't, and she was forced to stand trial on the basis of what amounted to a trumped-up charge and contend with fabricated evidence. Therefore, despite the formal categories not being met, in the substance, yes, she had been deprived of her liberty. Yes, she had been seized. And this is really a stellar example of judicial engagement.
Okay, let's move now to the Sixth Circuit, Evan.
So this case involves a couple of amendments to Michigan's Sex Offender Registry Act. Imposes a number of reporting requirements on individuals who have been convicted of sex offenses, broadly defined, and also imposes restrictions on their movements within the particular community in which they live. They had to stay 1,000 feet away from schools, with the consequence that they can't actually live within 1,000 feet of schools, they can't visit their kids at schools, et cetera, et cetera. It's a number of draconian restrictions that apply retroactively in the sense that an individual who has been convicted of a crime prior to the passage of this amendment still needs to comply with its terms, or they're subjected to criminal penalties. And the question in this case is whether that's consistent with the Constitution's prohibition against ex post facto laws, understood as retroactive criminal punishments imposed on individuals.
And what did the Sixth Circuit hold in this case, Josh?
Well, the court's reasoning was really interesting in this case because, first, it has to deal with an Alaska case, or a case coming out of Alaska in front of the U.S. Supreme Court that challenged a very similar set of restrictions back in 2003. This was the Smith v. Doe case. And in that case, the court set out a number of factors that courts should consider when dealing with ex post facto laws, such as whether or not the punishment was imposed is one that's traditionally considered punishment, whether or not there is an affirmative disability or restraint imposed, whether or not it promotes the aims of punishment, whether there's a rational connection to a non-punitive purpose, and whether or not, with respect to that purpose, the actual punishment or penalty is excessive. All these things courts need to consider in deciding whether or not a punishment is criminal. Now, remember, the ex post facto clause only applies to criminal prosecutions under an old U.S. Supreme Court case called Calder v. Boole.
Yeah. So the question in this case is whether this is a regulatory measure designed to prevent recidivism and thus protect the public, or it's just ultimately a way of imposing additional penalties on these individuals over and above that which they've already received. If it is the latter, then it is an example of ex post facto. It is an ex post facto law. It's retroactive criminal punishment, and it's unconstitutional. And what the court does is carefully perform a doctrinal analysis that's been honed over the course of years, looking carefully at the intent behind these particular restrictions.
And how the court actually goes about analyzing each individual factor is really interesting. The first factor, for example, being regulations similar to ancient or to traditional forms of punishment. The court goes back to ancient punishments of banishment, where someone who was convicted of a crime was banished from the local area. It mentions shaming and probation as other kind of stigmatizing or kind of status punishments that restrain criminal defendants in other ways.
And the conclusion that the court comes to is that even this, though this isn't identical to those ancient forms of punishment, it has a similar effect. There's actually a map that indicates the limited freedom of movement that these individuals have, the areas that are school safety zones, and thus they can't hang around for extended periods of time, let alone live, as a consequence of the Sex Offender Registry Act. The court actually goes into the question of whether this is calculated to prevent recidivism by pointing out that the only evidence in the record on point suggests that this actually, or these kinds of requirements actually raise the risks of recidivism by isolating these individuals from society. So ultimately, the court comes to the conclusion that yes, this is calculated to punish rather than protect any individuals against the perpetration of additional crimes. And there's also just a generally fascinating discussion of Calder v. Bull, which is one of my favorite cases for a number of reasons.
Another notable part of the court's reasoning, I think, was its kind of skepticism about the concept of loitering. Many courts might just say, well, loitering can be considered a crime, and therefore the kind of prohibition on loitering around certain areas is fine, and not actually go deeper, as this court does, into saying, wait a minute, this prohibition on loitering will actually have a real effect on people's lives. Whatever that broad term can mean, it's limiting the freedom and restraint of everyday living that various people have. And
there's also skepticism about the definition of a sex offense. You have one individual who's discussed here was involved in a robbery kidnapping that was not sexual in nature. It just happened to involve a female, and that was shoehorned within the rubric of a sex offense. So you have lots of individuals who are convicted of crimes that have nothing to do with sex offenses that nonetheless come under the scope of this statute.
And many years later, they're not allowed to go to their kids' school play because of it.
Right, or participate in parent-teacher conferences, or hang around playgrounds with, for even brief periods of time without fear that they will face heavy criminal penalties.
Does the state bring up any evidence suggesting that these laws are particularly effective in protecting the public?
And that's actually a good point, and a point that the court focuses on. There's very little evidence of that, and the evidence in the record actually points in the other direction. So what you ultimately get is a punitive measure that is not rationally related to any legitimate purpose in protecting people against recidivism.
Okay, let's move on to the final case. Josh.
Yeah, so this case is pretty straightforward. You have three judges who want to be candidates, or who are candidates in Kentucky for the office of judge. It's an elected office there. But Kentucky's Kentucky's judicial canon, which dictates the kind of ethical guidelines regulating judges, prohibits a bunch of campaign-related activity, such as claiming to be endorsed by a political party or giving speeches regarding certain political topics. So one of the judges wants to be identified himself, I should say, as a lifelong Republican. Another judge asked voters to re-elect her. And another judge wanted to give speeches to the Republican Party and hold Republican Party fundraisers. The lawsuit was filed by one, and the other two judges intervened.
One point of clarification, what do you mean when you say the judge asked voters to re-elect her? That sounds like something that would be pretty normal in the course of a campaign.
Yeah, it's interesting because she was actually appointed, and so the commission sent her a probable cause letter saying that her statement to re-elect her could contain a false or misleading statement.
Right. So Judge Sutton makes his way through each one of these provisions, and he engages in very careful analysis of just how vague they ultimately are. For example, an individual can give a speech in which they identify themselves as a Republican, but if they introduce themselves as the Republican Party's nominee, or they criticize the Democratic Party as such, they could run into trouble and get a threatening letter. But lurking behind this is a broader issue that Judge Sutton scratches the surface of, but really is something that the Supreme Court is going to ultimately have to resolve, which is that, as you pointed out, John, this kind of stuff, these kind of speeches are, the bread and butter of political campaigns. If this case didn't involve judges, we would have a very different state of play.
How so?
Namely, that all of this is constitutionally protected speech. And it's constitutionally protected speech that is treated with such care and with such scrutiny by courts that it's very difficult to sustain anything under it unless, and this is the key, thanks to a couple of Supreme Court decisions, those cases involve judges.
I think it's also worth noting that it's not just that this case involves judicial speech. I think whether or not it's speech is one of the issues that the court is kind of driving at, in the same way that the famous Buckley v. Vallejo case had to discriminate between contributions and independent expenditures. You have the court here doing a similar analysis where the judge accepting contributions is being treated as less speech, even though the court admits that this is the speech of, for example, donors wanting to contribute. But the court seems to be, and indeed does approve of regulations about contributions, but does not approve of the regulations keeping judges from saying certain things or making certain speeches.
Right, and the distinction that Judge Sutton seems to be relying upon here is that there's something fundamentally different about talking about yourself and your own political beliefs and political associations, or contributing money to another judicial campaign. And Judge Sutton views that through the lens of, well, this is kind of like trading political favors. It's kind of like quid pro quo that goes to the integrity of the judiciary, and therefore the state has a compelling interest in doing something about it. It's all very vaguely defined. I mean, what constitutes something that could legitimately cause people to lose faith in the integrity of their judiciary? It's a very difficult thing to analyze. And I think that if you had strict scrutiny deployed in a case that did not involve judges, you would get an easy answer, which is that all of this stuff is ultimately, except for one provision which targets the speech about pending matters before the courts, all of it would probably be struck down.
There's also an interesting discussion about endorsements and whether or not private endorsements are permitted under the judicial canon. The court says the court actually upholds the restrictions on the endorsements of judges. That is, endorsements that judges make as well as receive. And the rationale the court gives is that without restricting endorsements, the state would have no other way of targeting partisanship, and that these kinds of endorsements play exactly into the partisanship that the government is trying to prevent with judicial elections. But the problem is that there's not really a good dividing line here between judges, as Evan was just saying, between judges and other politicians. And instead of applying a straightforward First Amendment standard, a typical strict scrutiny, the fact that the court has to apply a special set of rules to judges makes this analysis very ad hoc and without any clear lines for judges to follow in the future.
Evan, there's also an interesting discussion of the nature of misleading speech versus just straight out lying.
Yeah, and I think it's worth pointing out, as Judge Sutton acknowledges, that generally in the context of political campaigns, the idea of states policing individuals for either misleading the public or outright lying to the public about particular things is just not something that the First Amendment tolerates. Nonetheless, in this particular context, the quote says it all, quote, "Judges are not politicians," unquote. Judges are simply treated as different, and the Supreme Court has actually said that you treat judges as different because of concerns about the integrity of the judiciary. So throughout this opinion, we kind of have an analysis that's deployed in a very specific context that is not generally reconcilable with established First Amendment jurisprudence.
Okay, that concludes the show. For more judicial engagement, check out Evan's lead essay in the current Cato Unbound, which has kicked off a spirited debate. You can find the link on our SoundCloud page. And so until next time, this is John Ross from the Institute for Justice, prevailing upon you to get engaged.